Hi, this is Jim Cunningham. Welcome to another one of our webinars, the right and wrong things to do when you inherit money. I have Winston Duggan here. He's an attorney at Cunningham Legal, and we've been working together to put this presentation together. Very important concepts to consider. Another very important concept is this is information only. This is not legal advice. So don't watch this and then go out and do a bunch of stuff and say, well, Jim and Winston said, so it's a really bad idea. And if you're watching this live, please go to YouTube and subscribe to our channel. And if you're watching this on YouTube, you can just hit the subscribe button below. And it's really important to subscribe to our channel because you really do stay on top of all the new and exciting legal changes that are out there. And we're forecasting a lot of change, not only next year, but also in the next 3 or 4 years. So I'm Jim Cunningham. I'm the managing partner at Cunningham Legal. I've got 25 years plus experience. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust and probate law, real estate broker, securities and insurance licensed. I'm also a private pilot. And this is Winston Duggan. He's an associate attorney here at our firm, and he graduated from Santa Clara University and Marquette with a BA in law and politics. And he's committed to helping children and families, has a strong background in family law. So he did that before joining our firm and a predecessor firm. And estate planning is his true calling. We've got 9 attorneys here. And so we've got a whole range. Well, all we do is trust and estate law. So we're sort of an inch wide and a mile deep. And these are office locations in Northern and Southern California. You can see the palm trees and the Golden Gate Bridge. So let's talk, Winston, we're going to talk about some right and wrong things to do when you inherit money. But first, I like to just, this is kind of a serious topic, death and inheritance and regret and all the stuff that kind of the bundle of emotions that go with it. But I think we should start with something a little lighter. And these are the top dumb things dummies do when dummies get an inheritance. And you remember that film, Winston?
Absolutely.
Yeah. It's a great film, classic comedy, Dumb and Dumber. It was Dumb and Dumber 2, spelled T-O. So these are some things that we see. Taking all the money out of an inherited IRA right away. That happens 87% of the time. 87% of accounts when the participant, so the owner of the IRA dies, 87% of the time, all the money's taken out right at once. The problem, of course, is what do you have?
Taxes.
Taxes, that's right. If it's a normal IRA, if it's not a Roth, dollar for dollar, every dollar in the vast majority of circumstances, every dollar that comes out is taxable as income. Okay. People forget about taxes, Winston. We see this all the time. They just take the money out of an IRA and they forget about it. They forget about capital gains taxes. They forget about if you have an AB trust, right? And all those assets go into the B trust, you're not going to get that second adjusted cost basis. If you don't know what that means, we have a whole bunch of videos on our YouTube page. I would really encourage you to check that out, where we take a deep dive into that, sort of the pitfalls of a living trust. Blindly paying off the house. If you pay off your house, but then you have a corresponding tax bill, let's say you take all the money out of an IRA and then pay off your house, where's that money going to come from to pay the taxes? And we see this a lot, Winston, people trying to make more money quickly. And I put very quickly there because you want to get rich slow. You don't want to get rich quick is the bottom line. And then becoming an immediate investment guru. I don't pretend, I'm securities licensed. I don't pretend to outsmart all the smart kids on Wall Street. They're doing that. They're playing that game 24/7, 7 days a week. If you think you can outsmart those people, when it comes to stocks and bonds, I'm not so sure about that. And then another one is not naming a beneficiary if your inheritance outlives you. Well, what does that mean, Winston? I mean, that means if someone inherits a bunch of money and they never do an estate plan, what happens to that money?
Okay. You're going to be in probate court. And
then you don't know who's going to get it, right? It's a mystery. I would say this is probably kind of obvious for people who aren't dummies. Don't talk about how much you've inherited. That's a really, really bad idea. Do we see it? Yeah. How do we know someone's inherited money? They go out and they get a fancy car. They do, whatever it is. Failing to seek competent professional help. Winston and I were just meeting this morning with a client who went through a fairly complicated trust administration when she lost her husband. She sought professional help. but you can't ignore this stuff. You know, there are a lot of esoteric, detailed things you need to do when somebody passes away. Obviously, going on a spending spree, overestimating the value of an inheritance. I heard a really smart person say, I got poor really, really slow, and then all of a sudden I got really poor. So meaning like you keep spending and then, oh, that last check bounces. So, you know, if someone inherits $1 million, that sounds like a lot of money. But if you're 50, that may not last you a lifetime. You know, it depends on your spending habits. Repeating bad decisions. So we see this, Winston, of course, someone will inherit money, blow it, then inherit some more money and blow that again. And, you know, we see that. And then I would say manufacturing conflict among heirs. You know, I think some people, and you saw this because you practice family law, is people will have conflict, not necessarily because of what's going on, but because of other things that have happened in their lives. And so this is the right. And so this is the classic example, Sally gets the red bike for Christmas in 1962, and Bobby doesn't get it, and Bobby's mad at Sally forever. So when mom and dad die, Bobby sues Sally because of the red bicycle she got. What were you going to say?
I was going to say money does funny things to people sometimes.
It does, right? And money, there's so much of the attitude toward money that plays into it. And this is something to bear in mind. I think people, when it comes to inherited money, they treat that psychologically different than earning it, and earning it from or profiting from investments. You know, hard work. You go to work, you save your 401k, you save that nest egg year over year over year, or you buy a piece of property and you sell it for a profit. I think people, what my experience and what I've seen is people treat it differently. And I think this is because emotions get in the way. I mentioned, you know, Bobby being mad at Sally for something that happened in 1962. Okay. I would say there's a level of sadness. Surprise is a common reaction when people pass away and they inherit money. They may be surprised at the amount of money. They may be surprised how they feel about it. They may be guilt. They may have guilt because they're relieved that the loved one who passed away, who was such a, so challenging to take care of, does pass away, and this person's relieved because they're no longer having to care for somebody. I mean, there are a lot of emotions that can happen. I'll tell you from my own standpoint, when my mom's mom passed away when my mom was 11. And when her father passed away, my grandfather, she was about 60 something. And she came to me, she says, Jimmy, I'm an orphan. I mean, here she is 62. She feels like she's an orphan. So there was a lot of emotion with that, obviously. I think people are vulnerable and you can make impulsive decisions. And this is why you hear, and I don't know if you've heard this a lot, Winston, I'm sure you have. Don't do anything for a year.
Yeah.
I would say don't get married for a year. Don't sell the house for a year, but please go see your accountant, go see your financial advisor, go see your lawyer, because there's a lot of stuff you have to do in that first year. But what we're talking when say don't do anything, don't make any major decisions. And I would say the major decisions in life are the who decisions. Who do you marry? Who do you have as a new friend, or whatever it is? And it's just hard to avoid those mistakes. So I've heard this, Winston, you may have heard this. People think they have to do something with an inheritance. Well, I inherited this money, I got to do something. Mom and dad left me $5 million. I got to do something. Well, don't be impulsive. Don't rush out and do it. And you might forget, some time goes by, you forget why you wasted that money. And sometimes buying something leaves you in a worse financial position, right? So if all you inherit is $100,000 and you go out and you buy a big truck, but you can't afford the insurance on it, I'm not sure you're in a better place. So how do you cope with the emotional? And I know this is a lot of, you might, if you're watching this, you might be thinking, well, Jim, when are you going to get to the right and wrong way of inheriting money? I think this is really important because, again, we're talking about an inheritance. We're not talking about a gift. And so these are really different. So an inheritance involves somebody dying. And typically it's somebody that you love. Sometimes it's not somebody you love, but most of the time it is. But I would say, Winston, we tell our clients it's okay to grieve.
Absolutely.
Right. And give yourself some time, because some things do change, especially if you've lost a spouse, if you've lost a life partner. That is a really big change. And And I would just counsel people not to rush into decisions. Don't feel like you have to rush, right? And then look at your own financial situation when you're emotionally ready to handle it. Look at debts, your dreams and your goals, and the impact of an inheritance. And see, I think it's good to rely on trusted family members because they typically are coming from a place where, they care about you as opposed to a new best friend, right? Somebody you didn't meet before this person passed away. And then, should you pay your debts down? Should you pay them off? That's a big question. What about setting aside for education? What about your own charity or travel? And I would suggest working with an A team. And we've talked about this in our prior videos. These are on our YouTube website. And work with, at a minimum, a savvy lawyer, such as the attorneys at our firm, a qualified CPA and financial advisor, to develop a long-term plan. And then that needs to be reviewed on a regular basis. So let's talk about the different ways to inherit. So maybe, Winston, if you can talk about the old way, because we see a lot of trust, right? We're meeting with people multiple times a day, and you're working in the estate planning sort of division of Cunningham Legal.
Yeah.
Tell me a little bit about the old way of doing things.
Yeah. So like Jim said, before we get into what we feel are the best practices when planning for receiving or providing an inheritance, we want to talk about what's been the standard way of planning and what I kind of see as a bare bones approach. And that's for a beneficiary to inherit directly as an individual and not in trust. And this is how we see a lot of lawyers drafting their trusts. When new clients come in and they ask us to go over their estate plan, for the most part, it has their beneficiaries inheriting directly. And so this is a mandatory payment directly to your beneficiary. And when your beneficiaries inherit directly, they're going to be inheriting, and the assets they receive will be titled in their name alone. They may even put the money they inherit into a joint account with their spouse, or they might put their spouse on title to the real property that they inherit. Now, there's nothing inherently wrong with this, but it assumes nothing will ever go wrong, that life will always go according to plan. And as we all know, sometimes life can throw you a curveball.
Yeah, and I say, here's the risk. Certainly first of all, people can die out of order. Meaning the kids can die before the parent, which has happened in my own family. But I would say here's the really big risk of doing things the old way. In California, if you're married, all property acquired during marriage is presumed to be community property. And you really can put a period on that sentence, okay? There's an exception. Unless the spouse who doesn't want it to be treated as community property, right? Because community property is subject to a 50-50 division at divorce. Unless that spouse can prove it was brought to the marriage, it was a gift or an inheritance. The problem is it is very easy. And as Winston indicated, if you put someone on title, if you put it into a joint account, does that automatically become community property? Well, the answer is no, but it might. So it's not clear. It's clear as mud. And I can tell you that when people are divorcing, some of them may start out as amicable, but the vast majority of divorces end up, it's, kind of bloody knuckles and it's all about the money. So that is one thing that I don't think we can ignore. And what is it, Winston? Half of marriages in California end in divorce. Yeah. And it's the burden of the person who's inherited the property to have that proven to be their separate property. Mm-hmm. Joint account is worse. If you put money in a joint account and you start making community expenditures and you tell the person, yes, honey, this is really community property. It's not my separate property inheritance. That's all evidence that weighs in favor of having the property be treated as community property. And the translation is your future ex-son-in-law or your future ex-daughter-in-law might end up with a chunk of the wealth that you've created, that you've taken a lifetime to create. Most people don't want that. I will say there was one exception in my 25 years plus of experience. And the client said, well, I'd rather leave it to my son's ex because I really like her better than I like my son. So go figure. But here's an example. Helen wanted to have a living trust that leaves everything to Seth, their son, in Seth's own name. And this effectively stuffs the inheritance into Seth's pockets. And 5 years later, Seth goes through a bitter divorce. So you can see here's an example of Seth inheriting the property and then later going through a bitter divorce and then having those challenges about, is it separate? Is it community property? you want to talk about bankruptcy and other lawsuits? What we see in trust administration, Winston?
Yeah, I mean, so in addition to the dangers from divorce, assets held in your name as an individual are subject to attack from lawsuits and creditors, and they're to be subject to bankruptcy proceedings. So imagine getting in a car accident or being sued for an accident on your property, and everything you own can be taken from you as a result of these lawsuits, and everything you or your parents have worked so hard for can disappear.
Yeah, I mean, there's one thing, it's called joint and several liability. If you're 1% at fault, you can potentially be responsible for 100% of what are called special damages, which would be medical expenses. So if you hit a van load of doctors on their way to a conference and you're 1% liable, your personal assets can be tapped into to pay all of the 100% of the medical expenses. So, and that's again, that's a California rule. So Cal and Wanda have a living trust, and that leaves everything to Doris, their daughter, in Doris's own name. So Doris inherits from Hal and Wanda, and then Doris dies 5 years later, and she's left everything to her husband by a will, and not to Doris's kids, Hal and Wanda's grandkids. And shortly thereafter, Doris's husband does what? He remarries. Shocker. So I will tell you, for those of you out there in the world, you probably know this already, because my wife and I joke about this. She says, if something happens to you, I'm not getting remarried. It took me 30 years to train you. I'm not, I can't go on to another one. And then, of course, the men get married 5 seconds later. So, so I think that's a real world issue. And if Hal and Wanda don't want their Doris's inheritance to end up going to Doris's husband's new, a widower's new wife, they can plan for that. So Charles asks, should I set up a planned inheritance of a property by allowing the trust to pay the mortgage, property taxes, insurance until I die? Yeah, that's one variation. You could certainly do that, Charles. Thank you for that question. So Subodh asks, so to protect from divorce, if our estate transfers assets to a trust, then the trust has to pay income taxes, et cetera. Aren't trust tax rates higher than individual rates? For Subodh, there are a lot of ways to tackle that. So when you transfer your property to a living trust, your own living trust, maybe with a spouse, there's no creditor protection, there's no divorce protection. It's just kind of what we call your alter ego. So if it's your own living trust, you're not paying taxes at a higher rate, you're paying those on your own low rates. It's when you pass away and that property then goes to your children, any undistributed net income conceivably is taxed at higher rates, but there are planning strategies to decant or to change the terms of that trust after the fact to make the individual child, be deemed the taxpayer, even though the assets are not distributed. So that's something we typically pick up on the trust administration after the client's passed away. So lot of risks out there. So, hey, how do you protect an inheritance? And I had to throw in an emoji. For those of you who don't know what emoji is, I guess you'll find out at some point. So modern inheritance strategies. I would say, Winston, the lawyers that I choose to interact with and speak with, it is rare that we have an outright distribution. Yeah, unless it's small. You know what I'm saying?
Yeah, I would agree. I think when I meet with clients and I see they have an outright distribution, I always recommend that their plan be updated to provide for inheriting in these continuing trusts that we've been mentioning.
Yeah. And so just so you get your head around some of the language that's used, and part of why we do these webinars, really, this is education. We really want to educate you. So you're watching this, either watching it live, you're watching it on YouTube. I mean, what a great world we live in. And, I remember thinking I was a history major growing up, and I thought, wow, wouldn't it be great to have lived in these great times of change? And I kept thinking about the past. And then I think about be careful what you wish for, right? With COVID and everything, forget that change. But this technological change, I learned so much from YouTube, and I really hope that you learn by watching this because I really Winston and I just want to share our knowledge with you. So with that being said, there's an outright distribution, which means it's stuffed into the beneficiary's pockets. If it's not an outright distribution, lawyers call that a continuing trust. So that's a term of art. So when a lawyer says a continuing trust, they go, oh yeah, someone's died and it's not an outright distribution. And whatever kind of continuing trust that is, and we'll talk about that in just a couple of slides, whatever kind of continuing trust that is, that's what we're talking about. So if you hear that, or if you go online and you're doing some legal research or research, if you see continuing trust, that's what it means. These are designed to protect the inheritance from creditors, and divorce. Creditor, somebody that the beneficiary might owe money to potentially. Creditor, I would put the government in there because, Uncle Sam and Uncle Newsom in California, right? They're going to want their pound of flesh, literally. And then, of course, divorce. And so the idea is this sort of multi-generational wealth stays with the family and its in-laws. So do you want to talk about the three types of trusts we have here?
Yeah. So generally, when we are moving away from the direct inheritance, there are three types of trusts: the Inheritance Protection Trust, and then there's the two other ones, what we call a Dole-it-Out Trust and a Special Needs Trust. But let's start with the Inheritance Protection Trust. And so the Inheritance Protection Trust is a basic continuing trust for your beneficiaries, and they're designed for a responsible beneficiary. And with the Inheritance Protection Trust, the beneficiary oversees their own trust as the trustee. They're in control of managing the investments and making their own distributions. And by the terms of the trust, the assets are protected and they would stay in your family and stay with your descendants.
Yeah, and I would say use of a trust protector is strongly recommended. This really lacks optimal functionality if you do not have a trust protector. And so we have a whole webinar on what a trust protector is, a whole video on our YouTube page. But if you don't want to watch an hour on trust protectors, just pay very close attention. A trust protector is a person who has power over the trust, but is not the trustee. So stated another way, a trustee must follow the terms of the trust. A trustee must execute, not kill, but execute, meaning it's an executory function. There are a list of instructions. The trustee must follow the terms of the trust. Sometimes there's limited discretion, but you cannot deviate from the terms of the trust. And a trust protector has the power to modify the terms of the trust, essentially, if everyone agrees, for administrative functions. Now, let me give you an example. If you are in Southern California and the trust says the trustee shall drive to San Francisco from LA, but the trust mandates that you go up Highway 99 or the 99 if you're from Southern California, right? And if you're in Northern California, it'd be Highway 99. So you're supposed to go up the 99, but everyone agrees, I don't want to go up Highway 99. I got to go through Fresno. I got to go through Modesto. There's all these, all these trucks and I got to slow down. I can't just, drive 80 miles an hour up Highway 5. If everyone agreed it would be better to go up Highway or the 5 if you're coming from Southern California, then the trust protector can say, we're going to change that provision of the trust to let the trustee drive up Highway 5. And that is an example of what a trust protector can do in a trust, where everyone agrees and where it makes sense. If you didn't have a trust protector, you'd have to go to court to modify that provision. And really, it's probate court you'd go to. The whole reason we're doing this is to stay out of probate, right? Anonymous asks, can the trust protector be the successor trustee? The trust protector can be the successor trustee if that is an independent person, which is not related or subordinate to the beneficiary. And that's under Internal Revenue Code section 672C, which means no ancestors, no descendants, and no siblings. So no parents, grandparents, no children, grandchildren, great-grandchildren, no siblings. Nieces and nephews are not 672C people. They're independent people. So Hallam wanted to pass away and leave Seth's inheritance to Seth, an inheritance protection trust. Seth is in control and makes distributions to himself for health, education, maintenance, and support. This maintains a separate property nature of Seth's inheritance and also provides a mechanism when Seth dies that the property in that trust goes where the trust says it goes. Now, sometimes we can have Seth decide to leave it to his spouse or for Seth just to not do anything and have it go to Seth's children. So that would be an example of an inheritance protection trust. The trust, and Anonymous asked, the trust protector cannot be a beneficiary, correct? Yeah, that you can't be the beneficiary. It doesn't work that way. Yeah. So you want to talk about a Dole-it-Out trust?
Yeah, so the Dole-it-Out Trust is a trust designed for your beneficiary who may not be the most responsible with their money habits. And with the Dole-it-Out Trust, the beneficiary is not their own trustee. Someone else manages the investments and determines whether the beneficiary should be taking money out of the trust for their expenses. Now, the beneficiary can still access the trust for their expenses for health, education, maintenance, and support. But the idea is that this ensures the beneficiary spends the money responsibly and not on sports cars or first-class airfare, gambling trips to Las Vegas. There would be an independent trustee, and the trustee, if they don't think the beneficiary will use the money responsibly, or perhaps the beneficiaries may be struggling with a substance abuse problem, the trustee has discretion to allow or not allow distributions from the trust to your beneficiary.
Yeah, and again, a use of a trust protector obviously strongly recommended because situations could change. I will say one of the problems, laws is kind of interesting because laws is a reflection of contemporary society and a reflection of society from a historical viewpoint. So one of the things we've run into is many practitioners, you mentioned substance abuse, many practitioners will say, if this person tests clean for drugs for umpity-ump period of time, then they get their money. Well, there's so many ways to game that system. And another thing in California, at least, is cannabis is legal. And so that's no longer considered one of those drugs. And, I have a lot of clients who have said, well, I don't want my children, to engage in certain activities. And if they do, then they're going to get dinged on their inheritance or they're not going to have full access to it. So in our firm, we tend to lean toward giving discretion to the trustee. And these paragraphs are actually very short because if you have 3 or 4 or 5 pages that talk about if the person's has a clean drug test, that just gives a wider and wider opening for the beneficiary to come in and get a distribution. This also actually works well for minor children as well. So maybe people who are under the age of 18 who are under what we call a legal incapacity. So an 17-year-old can't go out and open up a stock brokerage account. You just can't do that. You have to be 18. So Hal and Wanda pass away and they leave Doris's inheritance to Doris in a Dole-it-Out Trust, where a Nevada trust company is in control and makes distributions for Doris's health, to Doris for her health, education, maintenance, and support, or as Winston said, or not. Why do we pick Nevada? There's no state income tax. So if there's any retained income, including capital gains, if you have a Nevada trustee, it at least delays payment of the state income tax bill. And under current law, it doesn't eliminate it entirely, but any income that is not distributed is not taxed at California and is not taxed by California. So very important. Anonymous asks, is the trust protector stated in the revocable trust? The answer is yes. What happens if a trust protector is not stated in a revocable trust? Then you don't have it. So it's something you have to have in there. Anita asks, can the existing trustee make these changes after the death of the parents, for example? No. So the trustee must follow the terms of the trust. A trust protector has power over the trust and the trustee. So that would be done by the trust protector. Now, and that we'll answer that question. Basically, you have to do all this stuff in your living trust. You can't do it after you inherit. And we'll talk about what you can do after you inherit. And a special needs trust is designed for a loved one with special needs, including physical or mental disabilities or a chronically ill person. And for the people who, our loved ones with disabilities, many people are receiving public assistance benefits that are what we call needs-based. And these range from Social Security, supplemental security income, also known as SSI, Medicare, or Medicaid. It's Medi-Cal in California is the state implementation of Medicaid. A very popular strategy is a special needs trust. I will say that sometimes the amounts are so large that sometimes a special needs trust doesn't make sense. But I would say for the 99%, most people who have a loved one with special needs do create a special needs trust for that beneficiary. And again, use of a trust protector is highly recommended because sometimes people will move from state to state. The Medicaid program is state specific. So if you have a special needs trust in California and the beneficiary with special needs moves to Oregon, you very well may need to change that trust. In fact, you do. And that's why you should consider having a trust protector, because you would not have to go to court in that instance. Can a trust protector be added while the parents are alive? Yes, anonymous. So if you have a living trust, if your parents have this living trust and they don't have a trust protector, if they have a revocable living trust, which means it can be amended, you certainly can do an amendment. Most likely you'll do a restatement, which is kind of, a restatement is where you keep the address of the house, but you knock down the house and you build a new house. So what I mean by that is if it's a Smith family trust dated December 10th, 2021, then if you're amending the trust in 2023, you would keep that same 2021 date. So other inheritance trust considerations, you can provide more control and guidance, right, over the inheritance. Like this is not necessarily strings from the grave, but it can be. And more importantly, guidance. And I would say this fosters longevity of an inheritance. And sometimes what we do is we have staged access or staged times when a beneficiary will become a trustee. So it's not uncommon in estate plans in our firm for the beneficiary to be, the beneficiary is a person who receives the inheritance, by the way. Beneficiary gets the goods, the benes, the goods. It's not uncommon for that recipient of the inheritance to become a co-trustee at age 25 and sole trustee at age 30, okay? And you want to talk about a beneficiary receiving a specified percentage every year, Winston?
Yeah. So as part of, it would likely need to be under the Dole-it-Out Trust that we mentioned. You can set certain rules for the distributions that they receive, and maybe they receive 5% of the trust annually, or maybe you set a flat amount that they receive. But the idea is that rather than receiving a lump sum of money, there's a restriction to what they can receive. I think we've all seen the stories about people who win the lottery and take a lump sum of money, and then 2 years later, they've lost it all. And so with these inheritance trusts, whether it's the Inheritance Protection Trust, the Dole-it-Out Trust, you can kind of provide for some sort of restriction or guidance to prevent your beneficiaries from spending irresponsibly or otherwise losing their inheritance. I think the goal would be, you provide for your family and you provide for them in the next generation and for years to come.
Yeah, and really, I think it's funny, I've been practicing in this area of law for more than half my life. And as I've been aging, and Winston, you're younger than I am, and in our firm, we try and have attorneys of different ages so that we can have continuity with our clients. Because one of the questions their clients have is like, hey, Jim, if something happens to you, what happens to my family? Well, there are other lawyers in the firm, right? And they'll continue on. But I know my attitude toward wealth has changed, and I've seen my clients' attitude toward wealth change. And you can look at it as like, okay, well, this is my money and that's it. And my kids need to figure it out on their own. And then there are other people who say, wow, I live in Cupertino, or I live in Beverly Hills, or I live in La Jolla, and I would really like to see my grandchildren on a daily basis, and my kids can't afford to buy anything near me. And so then you start looking at your wealth as, well, this is a tool that I can use to see my grandkids more regularly, right? And it may be that you help your child buy a home, or you buy a home for a child, or whatever it is. But it's part of maybe a shifting viewpoint toward wealth. And I would say this is more common in the higher priced real estate markets in California. And locate a trust out of state. This is just kind of basic estate planning hygiene. Consider putting it out of state, because California, my goodness, especially if you're not distributing all the income every year, maybe on one of these Dole-it-Out trusts. So when do these need to be set up? Well, we had a question, can we just set this up after somebody dies? The answer is no. This is typically set up inside of the living trust of the person who's leaving the inheritance. They cannot be set up after death. They cannot be set up by the person receiving the inheritance, the recipient or the beneficiary in legal terms. I would just say expect the unexpected. And if protecting your legacy is important, you got to seek out a qualified expert, which we are. We also have attorneys that are licensed in multiple jurisdictions in our firm. We're located in California, but we do serve clients in other states. And you need to do this before you get hit by that proverbial ice cream truck or beer truck or yogurt truck, whatever you prefer, whatever truck you prefer to get hit by, right? But you got to do this before you pass away. So Anita says, I got lost. Who is recommended to take over instead of the existing trustee, a financial planner, CPA, or trust attorney? I think what we're talking about here, Anita, is a trust protector is typically it's somebody in our firm. And again, a trust protector is the person who has power over the trust, but is not the trustee. The trustee many times is a family member, and then they hire the A team, which includes the attorney, the financial advisor, and the CPA. Charles asks, you mentioned there are tax benefits to having the trustee located in Nevada. Should the trust protector be located in Nevada too? Great question, Charles. If the trust protector is serving in a fiduciary capacity, and that trust protector is a resident of California, it subjects the trust to income tax. When we serve as trust protector, we serve in a non-fiduciary capacity. So it should not subject the trust to income tax. Well, what if you've already inherited? There is still some protection you can do. You can set up inheritance trusts for your beneficiaries, right? So you can do this for your, right? So this is not so much the inheritance you'll receive, but this is what, if you've inherited this money, you could certainly set this up for your kids, for example. You can look at an irrevocable trust, which is a way of creating a trust that you cannot amend. But do you want to talk about a separate property trust, Winston, and what that is? And I think you're on mute.
My apologies. Commonly with people who are either they have significant assets going into a marriage or they're on a second marriage, we'll create a separate property trust. And it's just another layer of protection that makes abundantly clear that this property is my separate property. Now, unlike the inheritance protection trust, it doesn't also offer asset protection from lawsuits and creditors, but it does help to protect against divorce and keep the layer of protection to make sure that it's clearly your separate property.
Anita asks, if the trust is already set up in California, what could be done to set it up out of state? Typically that happens when it's irrevocable and we move the situs of the trust to a different state. Situs, or location, site, S-I-T-E, situs, S-I-T-U-S is Latin for site or location. We move the situs of the trust to Nevada. And that's how we can get it to become a Nevada trust. Now, if you have California source income, that's a different question, of course, but we're talking about typically things that are not California source income. Anonymous asks, if I have a trust with my children as beneficiaries, can I have one of my siblings who is not a beneficiary as trust protector? That sibling would be a 672C person. So that would be a person who's not independent, not a good idea. You would want to have at least a niece or a nephew. But we typically recommend that you have a professional, like somebody in our firm, a CPA, in that order, and then maybe a financial advisor. Maybe it's just that some of these things are so tax sensitive. You really should have an expert in there. Otherwise, you can step in it, right? But I want to thank you. Thank you for attending today. This is, we've covered the ways not to inherit. We've covered the things that dummies do when dummies inherit a lot of money, and we've covered the three different basic varieties of trusts, of inheritance trusts: the inheritance protection trust, the Dole-it-Out, and the special needs trust. Remember, subscribe to our YouTube channel if you're watching this on YouTube, and if you're not watching it on YouTube, go to YouTube and subscribe to our channel. Go ahead and you can sign up here if you would like to set an appointment to meet with us, or you can also, there's a webinar button on there. You can sign up for more webinars. And if you enjoy our webinars, please review us on Google. Google My Business, that really does help us. If you can put a nice positive review, that would be really helpful. And then we'll wrap it up here with a few more questions. If you have any questions, go ahead and put them in the Q&A. Thank you. Well, thank you, Anita, and thank you, Heather. So very informative webinar here today. And I just love talking about this stuff. And Winston, I had a great time talking with you today. And we look forward to seeing you in person and on video. One soon. Okay, great. All right. Well, have a great day, everyone.